Hi, this is Dan Smith of DPS Legal Counsel. Today I want to talk about letters of intent. A letter of intent is used in business law when two parties, typically two companies, are getting ready to negotiate the final terms and provisions of a contract or deal. Typically, letters of intent are used when one company is buying part of or all of another company's assets or business. And the parties know they're going to have to negotiate the fine details of the agreement before they have a final agreement, a final definitive agreement outlining all the points of the deal. But they want to set forth as many points of the deal as they have already agreed upon in some type of writing, and then set some kind of parameters about what they're going to do next, what the next steps are in trying to negotiate the remaining points of the deal. And so they enter into a letter of intent. Now, in most cases, and in general parlance, letters of intent are considered non-binding. But here's the key thing that to keep in mind in the business world. A letter of intent is essentially either it's a contract of sorts. It could be a contract to make a contract. It could be really a preliminary contract, but you have to be cautious because the language of the letter of intent is key to determining whether it imposes binding obligations on one party or the other. Typically, parties want to set the terms that they've agreed upon in writing, but they don't really want to have a binding agreement with the other party because they know there are too many points to work out, and both parties typically want to be able to walk away if they can't make a deal. So it's usually to both parties' common mutual interest to make clear that a letter of intent is not a binding agreement. So it's key to put certain express language in a letter of intent to make it absolutely clear that the letter of intent is just what both parties think it is, which is a preliminary outline or sketching of certain terms expected to be in a final definitive agreement that the parties may enter into, but the parties should make it clear in the letter of intent that the letter of intent is non-binding and doesn't create any contractual obligations. That kind of language needs to appear in the letter of intent in order for it to be clear that the letter of intent is itself not a binding contract. Now, oftentimes parties want to make certain provisions of the letter of intent binding. And so, for example, parties may want to make it clear that they're going to be providing proprietary confidential information to the other party in connection with doing the deal that they're talking about, and they want that confidential information that they provide to the other party to remain confidential. So there typically is a provision in that situation where there is a binding obligation to maintain confidentiality of documents that are obtained as part of the due diligence process. And so there may be a provision, should be a provision in the contract, in the letter of intent, that says that parties are going to be providing confidential proprietary information to the other party, and the other party, the party that receives that confidential information, agrees to maintain its confidentiality, not to disclose it, and that is a binding contractual obligation which survives the termination of the letter of intent, survives the fact that they may not enter into a definitive agreement. It basically is a perpetual binding agreement by the parties to maintain confidentiality. That's the typical thing you would put in a letter of intent to make sure that confidentiality is maintained. And so that provision you would want to expressly provide is binding. You may want to have a binding provision that says that the parties are going to negotiate exclusively with each other during a particular period of time, so that if, for example, it's a sale of a business, you don't want the business owner to negotiate or to maybe sell the business to another party while you're working to try to buy it if you're the buyer. So you may have a binding provision that sets forth a period of time that is exclusive between the parties when the buyer and the seller will work together, in which the company will not be sold to another company. That again is something you would put in the letter of intent that says that provision is binding and is a contractual obligation. Other than that, there may be certain provisions you want to make clear in the letter of intent are binding and create contractual obligations. But overall, it's typically the case that parties expect that a letter of intent is itself not a binding obligation. In other words, both parties want to be able to walk away, not enter into a binding definitive agreement. So it's important to make that clear in the agreement. It's important to make clear also in that context that if you say that you're going to attempt to negotiate an agreement, you disclaim the obligation, and it sounds counterintuitive that you're trying to make a deal, but you still may want to disclaim the obligation to negotiate in good faith, because by putting a provision in your letter of intent that says that you will negotiate in good faith, you may actually create a contractual obligation to negotiate in good faith, and that could could open a can of worms if the deal falls through. One party may claim the other party did not negotiate in good faith. So if you want to be able to walk away, you should not include a provision in your letter of intent that requires the parties to negotiate in good faith. You want to, you may say you intend to or whatever, but you want to say that there's no binding obligation, no contractual obligation to negotiate in good faith, and that the parties are free to not enter into the definitive agreement. If you don't do that, then if the deal does fall through, one party may claim that the other party did not negotiate in good faith. Now, in Tennessee, there have been some cases that have talked about whether there's a duty to negotiate in good faith. And at this point, the law appears to be in Tennessee that there's no general obligation, if you're talking to another party about a contract, to negotiate in good faith. A duty to negotiate in good faith only arises if you have an express contractual obligation to negotiate in good faith. And so in order for it to be clear that you can walk away in a letter of intent, you're probably going to want to consider having language in your letter of intent that says specifically not only that the letter of intent itself is non-binding, except for certain provisions that you set forth, like the confidentiality of confidential information or the exclusivity provision, but you want to also say that there is no duty, no contractual obligation, no duty to negotiate in good faith, because otherwise, like I said, one party may determine later that they feel that the other party breached an contractual obligation if the other party just doesn't come to an agreement. So if you want to be able to walk away totally, even to change some of the terms that are set forth as a go-by in the letter of intent, you need to provide that the letter of intent is not binding and that there is no contractual obligation, no duty to negotiate in good faith. Okay, sounds counterintuitive, but it's going to be in the best interest of the parties if they want to be able to walk away and not find themselves perhaps a defendant in a contract breach suit saying that they did not negotiate in good faith. All right, so that's probably more than you wanted to know about letters of intent. Letters of intent are important documents in business law when parties are looking to enter into a contract with another party, particularly if they're looking to buy or sell a business. But you have to be careful. The language in a letter of intent is very important. You need to make sure that you're not stepping into a binding obligation when you don't want to through the making of your letter of intent. A letter of intent is great for setting forth sort of a summary of the key terms that the parties expect to have in their final definitive agreement, but they want to make clear that what's in the letter of intent is itself not a contract, and that there is no binding obligation to enter into a definitive agreement or even to negotiate a definitive agreement. All right, I hope that helps. We'll see you next time.